Good morning, everybody. Thank you all for joining us today. We've got a couple folks hung up in the waiting room. Oh, there we go. Wonderful. We're all in the meeting. All right. Well, thank you so much for joining us today. It's been a little while since I've been with you guys. Ken was kind enough to take over last week when I was supposed to be with you because I was recovering from a late night flight back in from a week in Mexico with my daughter for spring break, and we got to watch the eclipse there. We were in a location where we had 96% of totality. So I thought that was very cool. My 12-year-old was completely underwhelmed and was like, what's the big deal, Mom? It's just the moon like in front of the sun. So, that was interesting. But anyways, I'm glad to be back with you guys today. And I'm going to start like I usually do with our Zoom housekeeping stuff. And the beginning of that is just to remind you to stay muted unless you would like to unmute yourself to ask a question. Your Zoom toolbar, depending on the device that you're using, is probably at the bottom of your screen, and that's where you're going to find your mute and unmute button, as well as the start and stop video button. So if you would like to have privacy, keep your video off. If you want us to be able to see you, you're welcome to turn the video on, whatever works best for you guys. And again, please do stay muted unless you would like to unmute yourself to ask a question. The best way to ask questions is to use the chat function, and that button is also on your Zoom toolbar, or it might be flashing right now because I put a message into the chat just a minute ago. And in that message, I remind you that if we don't get to your question today, which we probably will because we're light on questions, but if we don't get to your question today, or if you think of another question that you'd like us to cover before next week, please email it to info@condolaw.net by 4 p.m. on Monday afternoon. That gives us the day on Tuesday to research our answers and get prepared for the Q&A on Wednesday morning. In the chat is also the link to our YouTube channel where all of the videos for previous Zooms are posted. And so if you miss one, if you submit a question and then you're not able to make it, or if you just want to do some extra learning on a particular topic like reserve studies or audits or whatever the case might be, you can go to our YouTube channel, and not in the main YouTube search bar, but in the channel specific search bar, you can put in search terms. And as long as it's not something so common that we talk about it every week, like, I don't know, assessments or associations, you should get some good search results for any topic that you're interested in researching. Along the lines of submitting questions for the Q&A, we did announce last week that we are going to start capping the number of questions any individual person can submit at about 3 per week. So when you send us your questions, if you send us 5 questions, we'll just pick the first 3 and stick them in our Q&A for this week, and then you'll have to submit the other 2 for next week. So you might want to only send us 3 per week in case you have a preference in which order we address those questions. So we had a week last week where it's kind of feast or famine with the questions. Some weeks, like last week, we had 30 some questions. Other weeks, like this week, we have 7 questions. But last week, I think 2 people were responsible for 18 of the 30 questions that had been submitted. So we want to give a little bit of like equal airtime to a broader variety of folks when it comes to submitting questions. Another thing that we remind you guys about every week is that we are here to give general legal information, not to give legal advice. So please keep that in mind. In particular, please ignore people if they send you an email that says, look at this video and see what Valerie says at 14:32, you have to do this thing or you can't do that thing. And in fact, we've even gotten some questions submitted for the Q&A where the person is very clearly looking for sort of ammunition to either force their board to do something or get their board to stop doing something. And so that's not what we're here for. None of this is legal advice that is particular or specific to any community. You can only get that kind of advice from an attorney that, number 1, has an attorney-client relationship with you, but number 2, is familiar with your specific governing statute, your governing documents, and your specific circumstances. And so that's the reminder. We're not here for legal advice. And the chat is also not legal advice. So that's one reminder about the chat. The other reminder is, don't argue in the chat or do anything weird in there. Just use it for asking questions or asking for clarification. I almost feel like that disclaimer or whatever is not even necessary anymore. We used to have some trouble with that in the early days of the Q&A, but it's been a long time since that's happened. So we're happy about that. Just a quick reminder that we've talked about this before, but the Corporate Transparency Act is still being challenged by National CAI, and there's some court cases also pending that might affect its enforceability. So, you know, a lot of our clients are choosing to wait until later this year before they determine when and how they're going to comply. So we'll keep you posted on any developments as those might arise. And the time has come. This weekend is WSCAI's Annual Conference. It takes place at the Sheraton Grand Seattle. It's Friday, Saturday, and Sunday. We will be there. There's a LAC dinner and a silent auction to support the Legislative Action Committee on Friday night. And we've got several of our attorneys presenting or participating in panels at the conference. So we hope to see many of you guys there. We're in booth, I think 108. I don't know how I remembered that, but I think it's 108. So come say hi if you guys are going to be at the conference. We'll see you there. And like I said, we did have fewer questions than average or normal, I guess, for this week. So if you have a question for us, pop it into the chat. We will add it to the end of what we've got prepared. And without further ado, I'm going to jump into the questions. So our first question is this. Under RCW 6490-525, is it allowed or appropriate for the board to present more than one budget option and allow the members to select between them by vote? I understand that all of them would need to be included in the notice. And I think the short answer to this question is no. There's just so many different problems that we can envision arising from this scenario. But I think the primary thing is that the statute requires the board adopt a budget and then send it to the owners and hold the budget ratification meeting. Presenting two different budgets when neither one of them has been adopted by the board would not comply with the process required by the statute. The statutory language also makes it pretty clear that we are talking about a singular budget. And so I'm actually really quickly going to copy and paste some language directly from 6490-525 subsection 1A into the chat so you all can see what it is that I'm looking at when I read this. And it says, within 30 days after adoption of any proposed budget for the common interest community, the board must provide a copy of the budget, so that's a singular, to all the unit owners and set a date for a meeting of the unit owners to consider ratification of the budget, not less than 14 days nor more than 50 days after providing the budget. So it's very clear in the statute that we're talking about a singular budget. And I don't think the board can adopt two budgets because that would not work, right? They would be incompatible with each other. And I also think that part of the problem here is that you would have to have another meeting to ratify the budget that was approved at the first meeting anyway. So even if you decided to go this route, it would just create more steps, more confusion, more possibility for confusion. The other thing that I think is important to note is that the statute does not require an affirmative vote from the owners for the budget to be ratified, right? What it says is the board adopts a proposed budget, sends it out to the ownership, and then at the ratification meeting, unless the unit owners holding a majority of the voting power in the community vote to reject the budget, it's adopted. So you're not actually conducting an affirmative approval vote from your owners. And so again, this just gets confusing, and there's the potential for confusion, for competing budgets, and for somebody to challenge your process, right? One of the things that we say over and over and over again in these Q&As and when we talk to our clients is that procedure matters. And it is far more likely that an owner successfully challenges a defective procedure than that an owner successfully challenges the substance of a board decision or of an association action. And so you want to make sure that your procedure is compliant with the statute. If the issue is just that you want owner feedback before adopting a budget, just ask for owner feedback before the board adopts a budget, right? If you've got some maybe controversial projects that are coming up, you've got some timing questions about when you're going to do certain things and how much it's going to cost your community, and do we just do it all in 1 year, or do we break it up over 3 years, or whatever. If you want owner feedback, ask for owner feedback before the board adopts the final budget that you then present to the ownership for ratification. You can, for a special assessment, I think it's worth noting, offer 2 different payment plan options for owners to choose from if there's a bank loan. in the notice of the special assessment, you would include the payment plan and, you know, the lump sum payment and then the monthly option for payments of that special assessment. But that is still one special assessment. You're not changing the amount of the special assessment of the budget, as it were, for that special assessment. You're just allowing owners two different options for how they would pay it. So I think there's just too many problems with this approach, too much potential for either confusion and or successful challenge of messed up process. And so our answer to this would be no. If we had a client that said, can we do this? We would tell them no. Katie, did you want to add anything to that?
No, I think you covered it. And so I will jump into the next question, which is, I have a board who wants to install a camera subscription service in their HOA. This system would capture the license plate of vehicles and send it to a company that will look for red flags and alert the authorities and or the board if something pops up. Is this a product that they could employ? And without knowing more about the circumstances of this community and what's going on, our response is sure. But you should probably talk to your association attorney to see if it's advisable. There are some considerations when employing security, in quotes, or surveillance systems that the association board should be aware of. You want to make sure that the association is not promising that it will take certain action or that you're promising any safety or security of your residents or their things. And with that, you could consider adopting a policy. This is if you decide to go with the camera subscription service. Consider adopting a policy that discusses what the association will do or what they won't do, how the association will retain the footage, who monitors it, and what it will be used for, etc. All of that is because there is an argument that any footage may be a record of the association. So you want a clear policy to show how it will be handled, for how long it will be held, all that. We do question the value of such a service. We don't know the cost to balance against if it can only be used to track against database for the vehicle, not the person. So there's a lot that we don't know about this specific service versus if you install like a Ring camera or something else. Also, when installing anything that is not already there, you should look at your declaration to make sure that the cost of the new system is something that the board can do without owner approval, or if the expense is a capital improvement and would require owner approval for it. So that's for anything you wanting to install, whether it be a camera system or a playground. It may be a capital improvement, just don't forget about that. Valerie, do you have anything to add on this one?
Yes, I do. I mean, I'm gonna say that this falls into the category of just because you can doesn't mean you should. My knee-jerk reaction to this question was like, why on earth would you want to engage in actively surveilling the members of your community? Because this question isn't just about, should we have security cameras to make sure that everybody's safe in the parking lots? This question is about surveilling your owners, taking snapshots of their license plates and sending them to a company to then alert law enforcement of what, I don't know. I just think that unless there's a compelling reason to do this, the drawbacks, which include the risk of potential liability, like Katie was talking about, creating distrust within your community. I would hate to live in a community that did this. And the cost, I think all of those drawbacks outweigh the benefits by a lot. So I can't imagine a scenario in which I would think that this was a great idea. Again, that's my reaction as a person and not necessarily legal advice, right? Or it's definitely not legal advice because we don't do that here. But I part of what we work so hard to do as a community association attorney is whenever we are navigating disputes between the association and homeowners, even when we're collecting delinquent assessments from homeowners that are behind, we're always keeping in mind that you have an ongoing relationship with these people who are going to continue to live in your community until they sell their homes, right? And so I'm always looking at things not just through the lens of, is this technically legal, but how does this contribute to or take away from the sense of community within this neighborhood? And so I question the value of a scenario like this unless you're dealing with a really specific security related challenge within your community. All right, I'm going to move on to the next question. Can you confirm that WUCIOA for all applies to all associations, including condominiums, homeowners associations, and property owners associations? I could just answer this question by saying yes, and then moving on to the next one. Because yes, it will apply to all common interest communities, including PUDs, cooperatives, where a corporation owns the building and the shareholders live in it. So common interest community is actually defined in the statute. And I'm going to actually go ahead and copy and paste the definition into the chat. This whole paragraph, I think, will work. And the statute says common interest community means real estate described in a declaration with respect to which a person, by virtue of their ownership of a unit, is obligated to pay for a share of real estate taxes, insurance premiums, maintenance, or improvement, basically common expenses, right? If your ownership of the property within the community obligates you to share in expenses, that's a common interest community. So it's not even limited just to condo associations and homeowners associations. It also includes cooperatives, it includes townhouse communities, any community where there are shared expenses and real estate owned within the same community. So that's the long answer, but the short answer is yes, it applies to everybody. And I'm going to jump into our next question too. Well, Katie, unless you had anything you wanted to add to that one? No? Okay. Next question is also related to WUCIOA. And it says, I note on Legiscan that the effective date for Senate Bill 5796 is June 6th, 2024, but I've only heard you talk about the January 1st, 2028 date. For a pre-2018 HOA Act association, what needs to change, if anything, on 6/6/24 versus 1/1 of 28? And the short answer to that question is nothing. Nothing needs to change for non-WUCIOA communities until the January 1st, 2028 effective date. So some portions of WUCIOA were modified, and those modifications will take effect on most of them on June 6th of 2024. And they include a whole plethora of minor and even more significant revisions, including there's some revisions to like the insurance section and when you can assess a deductible to a unit owner, things like delegating authority to a master association, all kinds of like random and little and bigger changes to WUCIOA. But those only matter if you are a community governed by WUCIOA. So that means you were created on or after July 1st, 2018, or your community has since adopted an amendment to your declaration adopting WUCIOA as your governing statute. For non-WUCIOA communities, none of those changes matter because none of them are being made to the very, very tiny number of sections that apply to non-WUCIOA communities, like the budget ratification section. There's one other section that changes WUCIOA that doesn't take effect until January 1st of 2025. So that's interesting. Most of the WUCIOA changes take effect this year in June, but one of them has to wait until January 1st of 2025. I don't really know the rationale behind delaying the implementation of this change. And if you're interested, this is just a section that says board members and their close family members are prohibited from bidding on a unit that is being foreclosed on to satisfy the association's lien. So right now there's no statutory prohibition on if the association forecloses its lien against a unit, can a board member bid on the unit at the sheriff's sale or at a trustee sale? And there will be such a prohibition effective January 1st of next year for WUCIOA communities. So eventually this will also, of course, be true for everybody because of the WUCIOA for all part. But all of the WUCIOA for all parts, all of the stuff in the statute that makes it applicable to everybody and that wipes out all the old statutes, those sections, none of them take effect before January 1st of 2028. So if you guys have follow-up questions or you need clarification, feel free to pop that into the chat. I don't know, Katie, if you have anything you want to add to that.
Nope. So let's talk about records. RCW 6434-372 talks about association records. There's a similar statute in each, or similar provision in each of the statutes that say the same thing. But the question is, under 6434-372, records are defined what must be disclosed, and that includes some private records. does any other RCW section apply to a breach of confidentiality? The declaration says nothing. So without knowing more about what you mean of private records and or breach of confidentiality, it's hard to comment specifically to this, but we think that the statute protects most private information. And if the statute requires disclosure of a particular record, it's not a breach of confidentiality to disclose it. But complying with the statutory requirement to disclose a record protects the board from making the disclosure for most claims that they have breached someone's confidentiality. Basically, if the board is required by the statute to provide it, and they do, it's really hard to argue that it's a breach of confidentiality. But if they don't disclose it, and they should have, they're more protected than from the argument that they have breached someone's confidential record. Meaning you can't put, there's an expression, you can't put the worm back in the thing.
You can't
Like,
unring the bell. How about
you can't unring a bell or like put, yeah. Anyway, you can't undo something.
I don't know what.
Yeah, the horse back in the barn. I think that's what I was going with. Maybe it was like the snake in the can. Either way, harder to unring a bell. So generally, if you're concerned about whether or not something should be withheld, you should probably talk to your association attorney and they can guide you. But that being said, the statute says what records must be retained. And then subsection 5 of 6434-372 does say what records must be withheld. And there's a long list, but as we're talking about private records, it does include medical and personal records for specific individuals, existing or potential litigation or legal proceedings, unlisted telephone numbers and emails, individual unit files other than the person requesting, and contact information of anyone in an address confidentiality program. That's actually in a later subsection, but it also must be withheld. So the statute doesn't talk about what happens if something that must be withheld is disclosed. And likely the person who had their information improperly disclosed would have the right to take legal action. But again, it would be easier to err on the side of caution than to disclose something you're unsure about and be told you're wrong. There is an open debate as to ballots and showing how people voted, if that's considered private information. There's an argument that they belong in the individual unit file, and so they could be withheld. That's just something that's come up recently, so that one doesn't have a clear-cut answer. So like I said, talk to your attorney if you have a specific document that you are wondering or if it is a private record or not, and should or should not be disclosed. Valerie, do you have anything to add to that?
Sure. I will say 2 things. I don't want anyone to rely on our comments here in support of their decision to withhold records that they should disclose to the ownership. So I think there's very clearly a statute, there's a statutory protection for a unit owner's right to review association records, with the exception of a relatively small subset of records, right? So don't use confusion as an excuse to not disclose. Consult with your attorney if you're confused. And I know Katie already said that, but I want to emphasize that. And part of why I want to emphasize that is because I can't tell you the number of times, and one was very recently within the last month, a small self-managed condo association came to become one of our clients. And the reason they hired an attorney is because they got sued by a homeowner because the association refused to allow the homeowner to review records that the owner was very clearly entitled to review. So you don't want to end up in that position. And I think this kind of goes along the lines of like making sure you establish an attorney-client relationship before you actually need it. And somebody asked, what case is that? I can't give you that information. That's protected by attorney-client privilege. I would need my client's permission to disclose that. But in that particular scenario, the answer to the problem was essentially educating the board. Like, yes, there are these statutes out there that define association records. And yes, there are these statutes out there that protect an owner's right to review those records. And so you have to comply with that. Here's what you can withhold, here's what you can't withhold, etc. The other thing that I would like to say, just as a practical matter, is that just because you as an individual feel like something is private does not mean that it's actually protected from disclosure. So a delinquency report, for example, might feel like, gosh, that's like got people's, delinquency information and their account balances, and that should somehow be private. There might be an argument under the individual unit owner file that you could protect some of the information in a report like that, and that you might need to redact some portions of it. But the financial records of the association are subject to disclosure to the owners. So just because you feel like something is private does not mean that it's actually protected in terms of privacy by a statute or regulation out there. So I think those are my comments on that one. I'm going to jump into our next question. I am a new board member of a pre-2018 condominium operating under the Condo Act, so RCW 6434. There is some confusion of when the requirements of 6490 take effect for us. It seems that RCW 6490-095 and 525 are already in effect. When does the entire RCW become effective for pre-2018 condominiums? So I think we've already covered this, but I'm just going to answer it to make sure it's crystal clear. The entirety of WUCIOA 6490 is going to become effective and applicable to all communities, all common interest communities in Washington on January 1st of 2028. However, some provisions of WUCIOA do already apply to all communities, including pre-WUCIOA communities, HOA Act communities, Condo Act communities, and those include RCW 6490-095, subsection 525, which is the budget ratification section, and subsection 545, which pertains to reserve studies. These provisions have applied to all communities for a long time. So this is not new. This is not something that just happened this legislative session. So for example, the budget ratification section 525 has applied to all communities in Washington state since July 1st of 2018, when WUCIOA first took effect. And you may not have known that until just now, and that's okay. So now you make sure going forward, you fix your budget ratification process so that it's consistent with this statute. And the rest of WUCIOA will not apply to your community until July 1st of 2028, unless you choose to adopt WUCIOA as your governing statute before then. And then the other thing to keep in mind is that there are some sections that have existed in WUCIOA that are now being mirrored in the other statutes. So the records provision of WUCIOA was essentially exported into all of the other governing statutes 2 years ago. The voting sections, the proxy sections, the voting by mail sections, the electronic meeting sections, or the virtual meeting sections. So just because you are governed by a different statute, and just because only a few provisions of WUCIOA apply to you, doesn't mean there aren't changes to your governing statute that you should also be aware of. And we cover those pretty extensively in these Q&As. And so you can look back at Q&As, especially towards the end of each legislative session. So April, May-ish of each year, and you'll see a lot of those provisions. Did you have anything you wanted to add to that, Katie?
Nope. So I will jump into our last prepared question. So that gives people an opportunity to put any follow-up questions or more questions in the chat. Here we go. I am the president of an HOA. I have a very disruptive board member. When we have board meetings with our commission, he is very rude and unprofessional to members of the commission and volunteers. I'm just going to summarize the rest of what it says. Basically, he's not supporting the board. When they come to a decision, he publicly calls the decision stupid, and he's being really rude, and basically how this person describes it, not a community board member, kind of a jerk. They have tried to speak to the person and they don't care how they behave. And I seem to have no power to discipline or remove them from the board. It seems like the only thing I can do is call a special meeting of the commission and request the removal of the offending board member, which looks very negatively on the rest of the board, with the community, as looks like they can't handle themselves. And it's not something that they want to do. What are the options? So without providing any legal advice about this specific situation, there is no way to remove a problematic board member without a vote of the ownership And it's important to remember, you can't control the conduct of other people. So basically, people are going to be jerks. You can ask them politely to stop, but they don't have to listen. And there's not much, again, you can do unless your bylaws say otherwise, which we haven't reviewed, to remove them without a vote of the ownership. You don't have to be the one to call the meeting. It can be called by anyone in the community. So it could be another board member. It could be just someone who attends the board meetings and doesn't like his behavior. But without doing that, you're pretty much, your hands are tied. You can wait till he's up for re-election and then talk to the community and don't re-elect him. You could try adopting a code of conduct, but there's not much teeth to it because there's no real consequences for violating the code of conduct. Like I said, any owner can call a meeting. You could adopt decorum procedures for the board, but short of removing him and actually being able to control his conduct, you can control how the meetings are held and more closely follow Robert's Rules of Order for conduct at the meetings. So for example, you can implement Robert's Rules of Order, which says you can only discuss action items. If there's not a motion, you don't talk about it. Basically, you don't have an open discussion without, the notes say you don't have an open bitch session, which there's no better way to say that. So basically, regulate how you talk about it and don't let people just ramble on and on. If this problematic board member doesn't get a second from another board member, then you don't discuss the motion that was proposed and the topic dies for a lack of a second. You can have items for discussion on an agenda and very closely stick to that agenda. Any motion, yeah. There are a lot of things in Robert's Rules of Order that you can do. You could consider having an attorney or parliamentarian run the meeting for you. This may help people be on better behavior because there is an outside authority who can shut down notions that people have that are incorrect or answer any questions to clear up any confusion. This is more common on the East Coast. It's very common for them to have attorneys or parliamentarians at every board meeting and annual meetings. It's less common out here. I don't really know why. But it's important if you have a problematic or someone that you're disagreeing with at a board meeting, don't argue with them during the meetings. Even if they're lying, just let them speak, get their piece out, and record any motions or action items in the minutes and move on to the next piece of business. Basically, don't fuel the fire. If it's really, really bad, you can try and eject them from the board meeting. That will need more board member support. So you can try adjourning and reconvening when everyone's had time to cool down. And always have, meeting minutes should always reflect the actions taken by the board, but it may be worth adding a little more if there was a particular discussion on a certain item or certain action was taken, adding a little more explanation to it. Valerie, do you have anything you want to add to that one?
Yeah, I think so. One of the things that I think is most important when you have a disruptive board member is that whoever is chairing the meeting needs to be a strong enough personality to shut that crap down when it's happening, right? So I would have no problem running a meeting with a problematic board member. My daughter, on the other hand, who is an introvert and socially a little anxious, would really struggle, right? And so the tradition generally is that it's the board president that runs the meeting. However, if the board president is struggling with the meeting management component of the meeting, the board president can absolutely delegate that to your association manager, to a parliamentarian, to an attorney who maybe has a little bit of a buffer and has a better ability to keep things on track when somebody is trying to derail them. Katie, you look like you had something you wanted to add.
I was gonna say, we have at least one client and more considering having an attorney from our office present at every board meeting, just because there is slight contention and it does help clear things up. I was also gonna say, if it's on Zoom and someone keeps talking after you've asked them several times to stop, you can always mute them, which doesn't help if they like go online and start bashing the board, but it does solve the immediate issue.
Right. You know, the other thing I wanted to speak to is that there were a couple of comments in the rules about like, well, why don't you just use Robert's Rules of Order? I think the point here is there are certain people who follow rules and there are other people who do not follow rules. I wouldn't assume from the question that this community isn't using Robert's Rules of Order. It just sounds like they've got a board member who just doesn't give a crap about decorum or about manners and about following correct procedure. So really the question is, how do you deal with that, right? And so I think Robert's Rules of Order can be a great sort of outline for how to run an effective parliamentarian meeting. But if you've got somebody that's ignoring the rules, then you have to dig a little bit deeper for ideas on how to manage that situation. And I do think that, you know, if it gets bad enough, the board can adjourn the meeting and then recall it without that member. I do, you know, there are issues that are created by that decision, including, I do think you have to have board support as a whole for that approach, like Katie said. Also, there's a question of whether that might create an issue with board quorum. And so that might make it more difficult, in particular, if you have a small number of board members versus a larger board. So none of this is legal advice. These are all just suggestions. And I think one of the things that struck me when I was reading the question it says, it seems like the only thing I can do is call a special meeting and request the removal of this board member, which looks very bad about the rest of the board and the community as a whole, like we can't handle ourselves. And I think when you get to this point with a problematic board member, sometimes you have to think less about how bad it might look to the community and more about whether it is hampering your ability as a board to effectively conduct business on behalf of the association. And I also think flip the script a little bit. On the one hand, there might be some owners who are like, gosh, this board can't even manage itself. But there might be other owners who look at this scenario and say, I'm so glad that our board is proactively handling this unruly, disruptive member so that they can effectively govern on our behalves. So, you know, maybe that's a little Pollyanna of me, but I don't think it just looks bad. There's a comment in the chat that says, to this point, we had a disgruntled individual on the board who was causing anxiety and people feared joining meetings. When we set the standards and enforced them, speak to the motion on the floor, they became frustrated and left of their own volition. That can happen too, right? If you've got somebody who really is sort of towing the line, enforcing proper procedure at the board meetings and kind of shutting down or nipping in the bud this bad behavior, some people will just give up at that point. Maybe not everybody, but it's worth a try. So we have some questions from the chat. Katie, I guess I should ask, do you have anything else you want to add on that question?
I don't. I was just going to read our first chat question that's in like the main chat.
Go for it.
Can a board member vote to use a board member's own business as a vendor, or is this a conflict of interest? One of the board members has their license to stripe and touch up paint damage on the property. The board voted for her to be added as a vendor. She does undercut the competition and is expected to do a good job, but we wanted to know if this is allowed. The vote was unanimous. I'll just say one, and then Valerie, I'll let you do it.
Go for it.
I think if this were my client coming to me, I would have preferred that the interested board member remove themselves from the vote, because it just doesn't look good. But the fact that it was unanimous does, I guess, help. But again, we generally recommend that any interested board member on any issue, whether it be like repairing their own unit, if they're delinquent, if they're a vendor, not participate in the vote so that there's no conflict there. Valerie, do you want to add anything to that?
Yeah, it does sound like, you know, from the question that they got more than one bid or estimate from other companies. I think that is also helpful and wise if you're dealing with a situation where your board member is licensed, bonded, insured, all of those things, and they are one of multiple estimates or bids that you secure as a board, and then you vote and choose the one that is in the best interest of your community. I don't think it's an inherent conflict of interest to use a board member in that scenario, but I do agree with Katie that the interested board member should not be voting on that decision. All right, here's our next question from the chat. Is there a statute which prohibits condo associations from posting a delinquency report which shows unit owners, units, or names? We have heard from some managers in the industry that we should not allow our HOA to do this because it is illegal according to the fair lending and credit laws. It is our understanding that these laws don't necessarily govern condo and HOA associations. These HOAs post the monthly financial report for homeowners to view at their convenience. They simply want to provide financial transparency. Any guidance or suggestions you have would be greatly appreciated. As you might expect, I have an opinion on this. I think that you can provide financial transparency while redacting unit specific information from the report. There is no statute that prohibits an association from posting a delinquency report that shows unit owner names or unit owner numbers, unit numbers. But I think it is bad practice. I think in the past, in particular, when we were in a pretty serious recession, say 15 years ago, 17 years ago, there were communities that were trying to do this to like shame people into paying their assessments, and it just doesn't work. And because it is not effective, and because financial transparency is not compromised by redacting the unit owner's name or unit number, that would be my recommended approach for any client that asked me this question. I don't think you have anything to gain by including the names or unit numbers of the owners on that financial report other than the walk of shame kind of approach, and it just doesn't work. And so I think that it's a bad idea. Katie, did you want to add anything to that?
Nope. But I will read the next question, which I'm going to probably say twice. We would need to do more research on, and we're not providing legal advice. But that being said, while acknowledging that Good Samaritan laws protect individuals when rendering aid to one another, is there any inherent risk to the HOA for providing an AED unit in the common areas? Will the association be obligated to do ongoing maintenance or training, and could they be liable if they fail to provide it? So I think this is a great question that we can provide some comments to, but not an in-depth analysis, and definitely not talking about your own community. The first thing I'd want to look at is, are you required to have an AED in your common area? Because if you have like shops or something connected with your condominium, there may be a different obligation. But again, I don't know. I think it's a really...
Sorry, I just totally interrupted you. There's a question in the comment that says, what is an AED? It's a defibrillator. It's a medical device that can basically jumpstart somebody's heart if they're in cardiac arrest, and having them in a broad variety of public places increases somebody's chance of survival until an EMT or a paramedic can get to them.
Yes. And as to the question, if they would be obligated to do ongoing maintenance or training. So I was trained as a lifeguard at 15, and we had to practice with a defibrillator. And I will say they have come a long way, but they also have they make it so anyone can use them. They have a sticker that shows exactly what you should do. They talk to you while you do it. They tell you all the steps. So the training, I don't know who you would train unless you have employees who are there. In terms of the ongoing maintenance, again, without more research, I would treat it more similar to fire extinguishers, where the association does have an obligation to make sure that fire extinguishers are not expired and they're up to date. And I would think that that obligation would be similar to a defibrillator, basically just making sure it's working probably once a year. Valerie, do you have any other thoughts on this?
Yes, I would say that there is not inherent risk to providing one, but I also think having some sort of disclaimer is not a bad idea. I think if you're going to have an AED in your common areas, then you absolutely have an obligation to maintain it and to make sure that it is in good working order, that it's not, expired or whatever, not broken. That's not the right word. And again, I agree with Katie as far as training goes, that number one, they're relatively easy to use. And number two, unless you have employees, I don't are you going to train the owners on how to use it? That's a more specific question from community to community. But I absolutely think AEDs are great. They are life-saving machines to have in as many public or quasi-public places as possible. But if you're going to put one in, you need to make sure that it's maintained and kept in good working order. I'm going to jump to our next question from the chat. Pre-foreclosure notification. The association is governed by 6434. Is a pre-foreclosure notice required with each delinquency notice? If the association fails to provide the pre-foreclosure notification, does this prevent the association from pursuing foreclosure until the notification is provided? These are great questions. I'm going to preface my answer from saying this answer applies to everybody because all 4 of the governing statutes now have the same pre-foreclosure notice of delinquency requirements. So this is true regardless of what kind of association you are. The statute requires that you provide the first copy of the pre-foreclosure notice of delinquency, along with the first written notice to the owner that their account has fallen behind. That's a newer requirement that took effect in 2023. The pre-foreclosure NOD, as a preliminary or as it was originally introduced, that obligation arose in 2021. But in 2023, the statutes were all modified to add a second pre-foreclosure NOD and to specifically require that it is included in the envelope that you send to the owner when you first tell them that their account has fallen behind. And I can tell you that the legislative intent behind that, because I was very involved in drafting and negotiating this legislative change, was to get foreclosure prevention resources into the hands of owners as soon as possible. And so I have clients that have asked, like, do we really have to send this? We're never going to foreclose. We don't do that. Yes, you really have to send it. It is a statutory requirement, and it has to be included with the first written notice to the owner of their account delinquency. I know a lot of communities that are still not sending these because they haven't caught up to the statutory requirements. I will say that there is a little bit of it's not a safe harbor, but there's a backup plan in place, which is that when this bill was introduced, it did not originally contain the option for your association attorney to send it for you if you didn't do it. We negotiated for that, and we were able to get that exception or that sort of backup plan inserted into the statute. So the second question, so the first question is, do you have to give it with every delinquency notice? No, you do not. You have to send it with the first delinquency notice, and then no sooner than 60 days after the first one was sent, but also no sooner than the account is 90 days delinquent, you have to send a second one. And let's say in the worst case scenario, you didn't send any of them, but you send an account to your association attorney to like record a lien and send a demand and then pursue whatever other options you might have. Your association attorney can send these notices for you, but the same timelines and waiting periods apply. So you lose time if you guys don't do them when they're required by the statute. So send it with the first notice of delinquency. Send a second copy no sooner than 60 days later, but also make sure the account is at least 90 days delinquent. A lot of my clients are just choosing to include the pre-foreclosure NOD and every notice of delinquency because they don't want to have to keep track of these timelines and waiting periods and whatever else, okay? The second question is, if the association fails to provide the notification, does this prevent the association from pursuing foreclosure? The answer to that is yes. You are not allowed to foreclose until a number of prerequisites have been met, including sending the pre-foreclosure notices of delinquency. So it absolutely does prevent you from pursuing foreclosure until you meet the notification requirements of the statutes. Katie, did you have anything you want to add to that?
Nope. Do you have any more questions that were sent to you individually, or is there just one more in the main
Just one
chat?
more. Just one
Okay.
more.
Well, I will read it. The board has a meeting to discuss a roofing project with the engineering firm, not the roofing company. The meeting is not called to order. The meeting is not open to the association members, nor was notice given to the association members. A vote is taken on which roofing company to select. Is this a valid vote of the board?
We're not going
Valerie,
to answer that question. We're not going to answer that question. That's way too specific. And I mean, I think the person who asked the question probably has an opinion on whether it's a valid vote of the board. I think we can comment on best practices. I think what we can say is if you are a community with an open board meeting requirement, the best practice is to make sure your owners are given notice of meetings where the board is going to do business on the association's behalf, including taking votes. If you are not a community with an open meeting requirement, then that is not necessary. But I think that either way, the best practice is for boards to make decisions at board meetings and therefore record them in the minutes. But we're not going to comment on whether this particular vote is valid.
Do you want to add anything about working meetings?
Yes, I would love to. So we do have a number of clients, and we're aware of a number of boards that do things that they call working meetings to, it appears to us, avoid holding open meetings. That may not always be the intent, but if you are a community with an open board meeting requirement, you can't call something a working meeting to avoid the open meeting requirement, okay? If it is a meeting of the board at which association business is going to be discussed, even if you're not voting on anything, it's still a board meeting. And there are very few exceptions to the open meeting requirement when it comes to giving notice to your owners. So if it's super inconvenient to send the notice, that's not an emergency. You have to still send the notice, right? The only scenarios in which I can envision telling a client that it might be reasonable to hold a board meeting without notice to the owners if they have an open meeting requirement is if there's like a legitimate real-time emergency that requires board action immediately. And even in that scenario, what I would tell the client is do your best to give as many owners notice of the meeting as possible, even if it's not formal notice as would normally be required under the statute, right? So send out an email blast, text or call owners about the meeting, post it on the association website, put a notice up by the mailboxes, whatever the case might be. So if you're holding a board meeting on 2 days notice because you've actually got a legitimate emergency, do what you can to notify as many owners as possible, because that increases or decreases, and let me just flip this the other way, that decreases the chance that an owner could successfully argue that the board's actions in this scenario were unreasonable. The other thing that I will say is that we have a lot of clients that think things are emergencies that we do not think are emergencies, okay? So the other thing that I will comment about is that we have a lot of clients that are meeting very infrequently, if at all, as boards. And so they want to deal with everything on an emergency basis when it comes up because they don't want to hold regular board meetings. I don't think that that's a reasonable approach. And I think that approach is more likely to be found by a court to be unreasonable. So I think that's where I should leave my comments on this topic, because I could obviously expound upon it for many, many more minutes. But Katie, did you have anything you wanted to add to that?
Kind of in that someone had a follow-up comment, and so I'll talk a little bit about that. But in an open meeting association, are you required to provide notice to all owners of all committee meetings? And I think our answer is generally yes, especially if there are at least 2 board members on the committee and they have the ability to make decisions for the board. So the open meeting requirement is that all meetings be open, not just board meetings. There are exceptions for executive session, but those still take place at the board meeting. But remember, owners don't get to participate in the meeting unless you're a WUCIOA community where they have an opportunity to comment. But that's not them commenting on every motion. You can set a time at a committee meeting or a board meeting, whether it be at the beginning or the end, for like an owner forum, and then the board goes about their business. And I think with that, we can be done talking about meetings.
Yes.
The next question is, can a declaration override the RCW where the RCW says a person can be appointed to the board for the unexpired term, which means to me that the term must be unexpired?
So I'll jump in on this one and then you can add anything that you might like. I'm going to assume for the purposes of the question that what you mean when you say the term must be unexpired is that the board member who's being replaced was elected for 2 years and you can appoint their replacement within the 2 years, but if it's after the 2 years, then their term isn't unexpired. And so then what happens? Is that maybe part of the question? That's kind of where I'm seeing the question go, but please clarify if I'm missing the point. I will say that in general, statutes override the declaration. The only exception to that is if the statute specifically says otherwise. So sometimes the statutes will say something like, except as provided otherwise in your declaration, and then it will go on to state whatever the statutory requirement is. In that scenario, your declaration would override the statutory requirement if the declaration contained that specific information. But otherwise, if the RCW allows the appointment of a replacement board member, for example, and your declaration is completely silent, then the statute controls. And I will say probably 90% of the time, even more probably, it's the statute that controls and not the declaration if there's a conflict between them. The only time that isn't the case is if the statute specifically says that the declaration controls. So in answer to your question, it looks like the term is expired. There's nothing in the declaration that allows the appointment of a replacement board member, but because the statute allows it, it's allowed. Not giving legal advice, but that's how it works usually.
The only thing I'd add is that usually, I think the statute says that board members serve until their successor is appointed.
That's correct.
So regardless of if their term is expired or not, you're on the board until someone is appointed to take your spot.
That's right.
Or elected,
That's right.
correct.
That's right. I think that we are number one out of questions, but in number two, almost out of time. So I think we're going to just call it now rather than starting a new topic with only a few minutes left. So thank you all so much for joining us, and we will see you back here next week, and come say hi if you're going to be at the conference this weekend. Bye, everybody.